Okay, I think we're good. Good afternoon, everyone. My name is Stephanie Bowe, and I'm with the Louisiana State Bar Association. And welcome to our Law Talk virtual workshop series. This week is Lawyers and Libraries Week, which we do in conjunction with the American Bar Association's National Celebrate Pro Bono Week. And so we'll be presenting a Law Talks every weekday at noon this week. Today's Law Talks will be on child custody, and we have attorney Jessica Ballard with Southeast Louisiana Legal Services presenting on this important topic. I just realized I'm not sharing my screen yet, so let me do that. Right, so we're doing child custody in Louisiana. But before we get started, I need to go over a few important reminders. First, this presentation is being live streamed. Questions will be taken at the end if time permits and answered live. If you are watching at a library, you may walk up to the computer or ask the library staff to submit your question through the Zoom. If you're watching via Zoom, please use the Q&A section. And if you are watching via Facebook, please use the put your question in the comments section. Please remember, though, that all these comments are public and visible during and after the presentation is over. Finally, please keep your questions general and not case specific. The attorney can provide information about the law and legal processes, but they cannot give advice on individual cases. Also, please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on the information provided in the presentation without first seeking legal advice from counsel in your relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Civil Legal Navigator, which is the link is provided here on this page, and we'll discuss more about this later in the presentation. Also, the Louisiana State Bar Association's inclusion of a program is not deemed to be a statement or an endorsement of the views expressed therein by the LSBA or any members of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentations or materials were free of errors or will continue to be accurate. Statements in the presentations and their materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LSBA, its section, or committees. Views expressed are those of the authors and contributors only. All right, with that being said, I'm going to go ahead and turn it over to Jessica, who's going to take it away.
Thanks, Stephanie. Again, I'm Jessie Ballard. I'm at Legal Aid here in New Orleans. Our formal name is Southeast Louisiana Legal Services. I'm going to go ahead and start sharing my screen so we can go through some of these slides together. Just for people who don't already know who we are, we provide free legal assistance to low-income people, strictly on civil issues. So that no criminal stuff. That would really be a public defender, which I think people might be more familiar with. But we're sort of the same thing, but on family law issues, evictions, home ownership, your public benefits stuff, large variety of issues, and new stuff pops up every day that we're able to find out that we can do. We represent 22 parishes, and I'm currently the lead attorney in our family law unit in the New Orleans office. So now that you have a little bit of background information on me and what we do, I kind of want to go through why you're here. I'm hoping to give you some context for some of these things that in family law, in custody cases, that you're kind of able to research yourself. We all have, or most people have, access to information these days, but even having the information may leave you lacking some understanding of the processes and the requirements of what you read. So I want to go over some certain topics to try to give you a little bit more background. Just to give you a roadmap, we're going to go through some terms I'm going to be using, just so I'm not using them without some context there, but I think a lot of them are self-explanatory. And I just want to say that if anyone does have a question, pop it in the chat and I'll try to answer that periodically, especially a quick, what does that mean? because I totally get some of these are pretty esoteric sometimes too. So we're going to go through physical custody, what that means, legal custody, how you'd file, how you get things going, what happens after you file, maybe after you get a judgment, some very specific issues, and then we'll take fuller questions at the end. So your petition, also known as a pleading, it's the initial paperwork that you'd file, and that does cost money to file. In Louisiana, the only free pleading in the sort of domestic sphere is a protective order. So if you want to file for custody, you're going to have to pay money or fill out special forms that we'll talk about at the end that may be able to waive your court costs or at least put them on the other party. A self-represented litigant, someone who's representing themselves. Again, a little self-explanatory, but some of the forms will say SRL or you might even hear this referred to as pro se. So just to go ahead and clarify that. And then the civil code, all the other states in the union only rely on jurisprudence, what the courts have said previously, or what the legislature says. And in Louisiana, we have a little in between, which is the civil code, and it really guides us. And it is the beginning of your search when you're looking for legal guidance rather than the end, where some other states may use a code of criminal law or something like that to help explain what's going on and what the legislature told everyone to do. In Louisiana, we start with the code. Physical custody, who has the child physically in their care, legal custody, that is who gets to make decisions and when and how, and those are separated in Louisiana. And then co-parenting, again, I'm sure everyone's heard that term, trying to make joint decisions together. If you've been designated as co-custodians, co-parents, you're going to have to figure out how to make decisions together. So physical custody. Before we get to legal custody, it's important that everyone realizes, unless it is the most extreme situation, the judge generally grants each party some time with their child. It's very few cases that I have had where the other party is granted zero visitation ever. I mean, those are the worst circumstances. So you're going to be sharing your children with the other party. And these are some common schedules people might follow. I mean, everybody tries to figure out what works best for them, but a week on, week off situation may work for parties who live far apart, or they have extremely contentious relationship. They can't possibly be communicating very often, or older children who just say, you know what, I'm doing a week at mom's, a week at dad's, or whoever it is, and I don't want to be switching back and forth all the time. 2, 2, 3. So I know it's a little confusing the way it is because you don't switch at midnight, right? You might switch at 3 or 5 p.m. or something. But the calendar is showing 2 days party 1, 2 days party 2, 3 days party 1, 3 days party 2. It's a little confusing. And I think I just said that wrong, but it's 2, 2, 3, and it works out in really a 2-week schedule if you look at it. So everyone over those 2 weeks got 7 days, but you're switching more often. And I think that often works for, again, parties who live nearby each other and very young children, right? If you just had that baby, but you're not together and you've got to start sharing custody, it's really hard not to see your child for 5 to 7 days at a time. So you'd want to see them every 2 to 3 days as much as you could. Another option would be every other weekend plus 1 overnight. So that would be the party who likely is not the main decision maker, is not the main caretaker, but is trying to be as involved as they can. So they're getting an every other weekend schedule, but we're saying, hey, that parent can be a little bit more involved. They can do homework 1 night a week. They can do a school drop-off 1 morning a week. They can be a little bit more involved, and that can be because the parent is just hasn't been responsible before, or that party is just so overburdened with work. Maybe they work just constantly, even overnights, and this is all that they can do. So this is a good option for people, especially parties where one party was taking care of the child for so long on their own, and the other party wants to get more involved. This is a great starter schedule as well. So moving on, depending on the situation, parties are either granted joint custody or sole custody. In my experience, almost all of my clients come in and going, I want full custody first of all, Louisiana doesn't have full custody. They have joint and sole. I think what people are saying when they say they want full custody is sole custody. And again, just to talk about this physical element again, just because you're a sole custodian does not mean the other party isn't seeing the child or children. Doesn't mean that they are not involved in some way or you're not dealing with them a lot. You may be doing so. So just to kind of put that out there. So joint custody is the default. Most people end up having a co-parent, joint decision making. They also have to, you know, everybody's responsible for all the necessities at their house. Everybody's responsible for getting the homework done, for getting the uniforms, if that's the case, to travel back and forth to each house. In joint custody, generally one parent or party is designated the domiciliary parent. That does not necessarily mean the parent that the child spends the most time with. It may be a almost 50-50 split on time, but the domiciliary parent has a little bit more decision-making power and a few more responsibilities. So when the parties need to make large, big decisions on things like, where's the child going to go to school? Are we having a medical issue and we need to choose certain doctors? And are we going to be confirmed in our certain religion that we've been practicing in, or only one of us, or we have different religions? Who knows? That domiciliary parent gets a second vote. So if each parent has a vote, we're making all the decisions together. Domiciliary parent has a second vote and then gets to make the decision on that large decision. However, the non-domiciliary parent has an option to object in court. They can file for an objection and say, hey, I think this is the worst school choice we've ever had. The child is failing. Here are all these reasons. And then the judge will assist them in making that big decision. Otherwise, as joint custodians, you each have decision-making power on buying the school shoes, getting haircuts, all those little things. The domiciliary parent is not the dictator. They just have a little bit more decision-making power on really big decisions. And they have some more responsibilities. You've got to keep the other parent involved and updated. And if the domiciliary parent is the one making all of the medical appointments, that's generally the case, you got to keep the other parent involved, the other party, whoever it is, make sure that they're aware of all the things going on with the child. So again, it comes with decision-making power, but it also comes with more responsibilities. And if you fail to keep up with those responsibilities, you may lose that domiciliary parent status. Like I said, this is the default option. And also you can choose not, if the judge doesn't see that it's necessary to choose a domiciliary parent, or the parties come to an agreement on this. We'll talk about agreements in a minute. A domiciliary parent does not have to be chosen. So sole custody. It is difficult to achieve unless the circumstances, like I mentioned earlier, are really difficult. You have to prove this by clear and convincing evidence that the other parent is failing as a parent, is a terrible choice to be the decision maker. Really, the most winning argument is that the other party has a substance abuse issue and is unable to parent, as there's been domestic violence perpetrated by the other party, either onto the other parent or the child, or honestly, it could be other parties as well. If there's a person that has multiple domestic violence convictions, say, hey, this person is really not able to be trusted with this child's physical safety because of their history of domestic violence. And then of course, incarceration. If you're in jail, you probably can't be a custodian. And like I said, it's much less common because it is so difficult to achieve because of the standard of evidence. It's clear and convincing. It's only one step down from without a reasonable doubt, which is what we use for convictions in criminal cases. And like I said, they're totally separate from physical custody. So you could be a sole custodian and you still have to share physical time with your child. Okay, so going back sort of to joint custody, the best interest of the child is what guides those determinations. That is a Civil Code article, Civil Code Article 134. It is about 14 points of interest factors that we'll go over in a little bit. But that is something that the judge will be considering. But before you get to the judge, you may decide that you can come up with an agreement with the other party. either the two of you or your attorneys, or one attorney on one side and the other person is a self-represented litigant. All of those combinations can work to come together to make an agreement on custody. We're going to share joint custody. We're going to do every other weekends for one party. We're going to share time in the summer. Whatever it is, you can come up with an agreement, and generally it's going to be accepted by the judge, rubber stamped, because they really want you to come up with an agreement. What's better for you than you knowing your own schedules and everyone's abilities and everyone's sensitivities than that? Or is it better for the judge to decide this is what we're doing, regardless of what everybody thinks and feels about it, right? They're the one making the decision, because it kind of is better when you come up with your own roadmap for how to parent your children. Again, domestic violence could be an issue. If there's a protective order in place, the judge is not necessarily going to say, okay, all right, parent who we've just decided is a domestic abuser is going to have unlimited time unsupervised with this child. There's going to be certain factors the judge may have to consider like that. If there's no agreement, judge will award joint custody unless, again, you can provide clear and convincing evidence that sole custody is the best choice. Those potential interest factors, one, potential for abuse, right? We're talking about domestic abuse in the past. Love, affection, and emotional ties. If the other party has had zero relationship with the child, and let's say they're 4, 5, 6 years old, probably going to have to start with sole custody on one side and work towards something else and establishing a relationship with the previously absent parent. Capacity to give love, to provide for material needs. That doesn't necessarily mean that you have to be employed to have custody of your child, but it does mean, can you keep a roof over their head? You can't necessarily take the child to every shelter in town and remain the sole custodian or the primary parent. Or if one parent's unfortunately living out of their car, it may be an issue the judge takes into consideration that the other parent is able to provide stable housing. Permanence of the family unit, length of time in stable, adequate environment, moral fitness, mental and physical health of the parties. We already talked about substance abuse, home, school, and community history. I think that's kind of a big one. A lot of times people want to get custody and move the child immediately to closer to where they live and where they're in school. And the judge is really going to take it seriously that if this child has been in their school for a while, has been active in their community, has been on the dance team or in the band or on the soccer team, we're not just going to move them because the parents can't agree and one of them really wants to go closer to their house. We're really thinking of the child's best interest and not necessarily what mom and dad or whoever it is would prefer. And then talking about preferences, reasonable preference of the child. If they're old enough, their preference is considered, but it's not necessarily easy to get a child in front of the judge. Not every judge wants to speak to a child, and if they do, there's a special hearing that may be required called a Watermeyer hearing, which a party will need to file for to get the child in front of the judge. And generally the parties are not present at the Watermeyer hearing. It's just the judge, the court reporter, and possibly the attorneys. Ability to encourage a good relationship between the child and other parent. This is kind of a big one too, is a lot of parents think that they can really mistreat the other party however they'd like, and then still be considered a good option for co-parenting. You can't cuss the other party out on text messages. You can't show up at their house in the middle of the night yelling at them. You really have to watch your own behavior and how you treat the possibly the other parent to your child. So that's definitely considered. And then distance and responsibility for care previously exercised. Like if one person has always been doing this and now the child's 13, that's certainly going to weigh in that person's favor that they've been doing a good job, and why not continue that? Let's see, where are we on time? Okay. All right. So if you are told you must co-parent with this person and you still are not a big fan of them, we can't communicate, we just have a really hard time doing this, there's things that can help. There's co-parenting apps. There is an app that's free called App Close. I'm not the biggest fan of it because at this point in time you can delete messages that you may have sent. But the reason for the co-parenting apps is so that you have a way to communicate in writing that is recorded in a way that, let's say you lost your phone, you dropped it in a puddle, that should be backed up on that app. So all you have to do is log in and get those conversations. And you've either agreed to or been ordered to use it, so we don't have to worry about authenticating text messages the way that we would according to the code of evidence, which can be difficult. Everyone thinks you can just bring in screenshots of messages, and it may be a bit more difficult than you think to prove that who said that was the person you say it was, and they said it at the time you said it, and they said it to you. It's a little difficult. So the parenting apps can really help. Our Family Wizard is a great option. You can't delete messages. They've got scheduling options in there. You can do phone visits on the what is it called? FaceTime or video chatting through Our Family Wizard, and as well as financial transactions can be paid through or at least marked in those apps. So I think they're a great option. Again, you could just use text messages, and if you really get along just fine, you can call each other on the phone all the time if you want to. But there's a lot of parties who really I need proof that I was there when I said I was, that the other party failed to answer me, the other party cursed me out, unfortunately. So these can be a great option for preventing some bad behavior. The co-parenting guidelines. You may be ordered to use these even if it wasn't something that you felt like was necessary to you. It's a 10 point just guideline that shows you how you should behave as a co-parent. So you want to share information about the school, about medical information, about medical appointments, about the winter pageant that school that's at noon, and just share that information if you are the parent, either who's a sole custodian or a co-parent. Because even the sole custodian, you may want to say, hey, your daughter would love to have you at their recital or whatever it is. And then co-parenting guidelines also have a bit of that language of you need to be able to facilitate a good relationship. So you can't talk poorly about the other party in front of the child. And it also mentions not moving more than 75 miles away from the current jurisdiction so that you don't impede whatever agreement that you've been given or granted by the judge. And then keeping contact information updated as well. Don't move, don't change your number without telling the other party because you have a child in common. You need to know where each other are and know where each other lives. Okay, so we've kind of gone through a lot of the big abstract part of custody. So how do we actually get it on paper? Starts with your petition. They have self-help forms, as well as your attorney may file something for you. And you don't have to be divorced to get custody. You can be married but separated, or you were never married, or you could be a third party. We haven't really talked about that, but third party custody does exist. So the non-parent custody could be grandma, grandpa, aunt and uncle, or really I've had even a godmother successfully win non-parent custody. You have to get the other party served. So even if you heard that they know about it, or they've texted you that they know that you filed for custody, you have to have proper service. That means the sheriff going out to their home, that someone has to open the door and say, yes, I am this person, or yes, this person lives here. I will accept service on their behalf. That's personal service and domiciliary service. The other option would be if they lived out of state, you have to get long arm service. I'm not going to get into that. I really recommend contacting an attorney, but it does involve mailing it out a certain amount of time and then getting proof that they received it and putting it into the record well before the court hearing. So it's a bit difficult, but you can serve out-of-state defendants as well. So then you'll get a hearing date. Depending on your jurisdiction, everybody's different. You may get a hearing with a domestic commissioner. You may get a hearing with a hearing officer, or you may go straight to a district judge. In New Orleans, we have district judges. In Jefferson, depending on the issues, either go to a domestic commissioner or a hearing officer. I think it's the same thing in St. Tammany. St. Bernard just has the district judge. So it's really all over the place on what you may be dealing with. And we already talked about agreements a little bit. You may get that hearing date, and if you think that you can get your agreement down on paper, again, this probably would take an attorney to fill this out for you, but you can submit a consent agreement without going to a hearing. Your Honor, we've worked out every bit of this, and all the parties have signed. Here you go. Judge stamps it. you don't have to go to that hearing date because you already have your judgment. Now, if you don't have a judge, if you don't have someone to type up a legal pleading for you, you can both go to the court and say, Your Honor, we have an agreement, and the judge will say, what's your agreement? And they say, we've agreed to joint custody. Each party gets week on, week off. We're going to use our family wizard. We're going to split the summer. Everybody gets every other holiday, whatever it is that your agreement is. But try to be thorough if you're going to do that route, because you don't want to say, yeah, we're friendly, we can agree, and then 6 months down the road, we didn't think about Christmas, and now we're in a fight, right? And you'd go back to court, and you may not get into court before Christmas. So just be aware that you can definitely work things out on your own, but I really recommend at least speaking with an attorney. Say, hey, I don't really need representation. I just want to make sure I'm not missing anything. All right, so the self-help desk. This is where you'd be doing this on your own. And the self-help desk often is staffed by an attorney, like in New Orleans and in Jefferson. And I'm just using these parishes because these are the parishes that I practice in most. But some parishes may not have a manned help desk. They may just have a kiosk with forms. And this is really where you want to reach out to somebody if you can, or reference Law Talk like this. A lot of people can accomplish these things without an attorney, and it may save you time and or money. So see if your parish has those services. Make sure to check out the LSBA link here, as well as there's the Louisiana Clerk of Court. And like I said, you may be able to find these forms at your local courthouse. Let's see. Okay, so court costs. So like I mentioned at the top of this was there's only one free domestic pleading, and that is the protective order. So for everything else you file in court, they want money for each piece of paper filed, right? So because they've got to keep the lights on, the roof over their heads, etc. That's what court fees are in Louisiana. So if you can't afford to pay, you're going to want to file an informa pauperis affidavit. So it's a bit involved, but you're going to want to list everything about yourself, truest to the best of your knowledge, and you're going to attach either your proof of income or your proof of benefits and say, hey, because of my low income, I'm really not able to pay the court costs, because it can be between $300 and $600 up front, and it could be costing you more. Let's say you have to get service repeatedly, or you have to file modifications or file rules for contempt, which we're going to talk about. All of those things are going to cost money, and you're going to really wish that you had that informa pauperis affidavit saying this person's court costs are either waived or pushed to the end and pushed on the other party. So I think that's a really important thing, and that's where you're going to need a notary. You're going to need a witness. You're going to need your ID. Your witness needs an ID, and like I said, that proof of income or benefits. You're going to want every piece of that puzzle because it's huge to get your court costs waived. Let's see, contested custody hearing. So like we said, you could hopefully get an agreement, or you have to go to court and you have to argue about these things. You or your attorney is going to present your evidence and your witnesses. If it's just you, the judge is going to really conduct this hearing. They're going to say, okay, party one, what's your case? And they're going to ask you a ton of questions. Well, who was the child living with? Really going to go over those best interest factors and any other little questions the judge may have. And they can ask you anything. You're really going to want to show up on time, so go ahead and contact the court if you're confused as to, oh, it says 9:30, but I heard the court opens at 8:30, or is my court hearing really at 9:30? Most of the jurisdictions that use the district judge model, it's really kind of a cattle call. You might be starting at 9 a.m. You may not be heard till 1:30. So be prepared to be there all day. I tell all my clients, eat a good breakfast, bring a sweater. Sometimes it's freezing. And you really could be there all day long. So I hope that you ate something to settle your stomach, and dress appropriately, not just the sweater, but make sure that you look like somebody the judge goes, yes, this should be the person I award custody to. That doesn't mean fancy. That doesn't mean you need to wear a suit. That just means to make sure you are looking clean and rested, even though you may not have slept the night before, because I get it. It's nerve-wracking. And then a lot of the courts have issues with head coverings unless they're religious coverings. So don't wear a hat, don't wear a bonnet, don't wear a scarf unless it's religious, and you can say, this is my religious head covering. And then also just don't wear anything that's too revealing or provocative. Or even your funniest t-shirt. Don't wear your funniest t-shirt. It's probably not funny to the judge. And then a lot of people really think that they are supposed to be bringing their children to court, and you're not. The kids should not be at court if at all possible. We did talk about the judge earlier, considering a preference, and that may be something you need to contact the judge's office about. Should I bring my child? My child is 16 and wants to speak to the judge or speak for themselves. Okay, they may say, sure, we don't care. We love that. Bring them on in. Or they may say, no, you need to file that Watermeyer motion that we talked about for that special hearing. But everybody else is really and the 16 is just an example, but everybody else is really supposed to say, no kids at court. It's not good for a child's psyche to say, my parents are fighting over me. I'm going to have this memory forever of me in this courthouse. It's not good for them. So we try to do that without, we try to go through the whole process without bringing kids into it unless it's really necessary. Okay, so you've gotten your judgment. Whether you like it or not, you got a judgment. There's gonna be problems probably at some point. Hopefully you guys can work it out via text message, via those parenting apps, whatever it is. If you really are having a problem, generally it's repeatedly or something really, really serious. Not just the serious in your feelings, but serious as that like could cause harm to this child, danger. You can file a rule for contempt, right? So a rule for contempt is a piece of paper that puts you in front of the judge to say, hey, this person is in contempt. They're in violation of not following what they were ordered to follow or agreed to follow. They have the forms at the self-help desk on the clerk of court's website. You need to go to your hearing and you need to show the judge. You can't just say, she's always late or he never feeds them breakfast. You're going to have to come up with something that says, hey, this is actually happening. So I normally say confirm via text message, make a recording if you can, get a note from the school that says on every day that mom or dad had the child, they've been late. All the tardies that racked up were parent one's problem, right? So go to court with your evidence because it's really hard to say, well, they're doing something bad because they're just going to turn around and point the finger at you and the judge is going to be a little frustrated and send you all home. You can also file for a modification, which is a motion based on circumstances or substantial harm. So if there's been a change in circumstances, mom's gotten a new job and she absolutely cannot do morning pickups anymore, whatever it was, the party would file for modification and say, hey, we need a new schedule because there's been a new job or someone has moved or gotten married or had another baby, whatever it is. And so you would seek not necessarily a rule for contempt because they're not trying to violate it. They're just, things are different. Or you could say there's been substantial harm, like I mentioned, the tardies. You can go ahead and file your modification along with your rule for contempt. They've been late every day for 2 months when they were with dad. And I want to go ahead and change the schedule so dad doesn't have them anymore on school mornings, right? Because it is harmful for a child to not be getting school on time because it's going to affect their grades and all that. So the last thing I would say is if you really feel like the other party, it's just a 1 or 2 time thing, you can call the police and say, hey, this person is not returning my child. They've just gotten dead quiet. They're not communicating. I'm going to call the police. As long as you have your judgment, you can go ahead and say, look, officer, here's what the judgment is. Could you help me get my child? That is truly just sort of a Hail Mary because police are generally supposed to say, this is a civil matter. We're not going to get involved here. But every cop is different. Every day is different. Every cop's understanding of the law and what they should and shouldn't be doing is a bit different. But law enforcement may help you and say, yes, I'll go ahead and help you enforce this judgment the way it's supposed to be. That just depends, on luck of the draw. Okay. DV and child abuse. We talked about this a little bit earlier. I'm not going to go really into it because I think we've addressed most of these topics, but domestic violence is usually how you might start a custody case. It's very rare that I see that the domestic violence begins after the custody has been filed or been ordered. It usually starts with a request for a restraining order and then moves into a request for custody. But it does happen. And abuse may occur from not just the other parent, but from their new spouse, from other siblings. So definitely try to keep your proof, call the police when you need to, file a protective order if you need to, consult an attorney if you can. Okay, the relocation statute. So I have a lot of people who come to my office and say, I want full custody. And they say, and I want to move to Texas, or I want to move to Atlanta, or we're going to Chicago next month. I go, whoa, 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 whoa. You may have had this child their whole life, and now just things have been kind of starting to cook up and you're just ready to get out of here. And you may be in a hurry, but you got some steps you got to go through if you even have a prayer of having this approved. So the relocation statute applies whether you know it or not already to you. It applies to you right now because it's a revised statute. So you don't have to agree to it or know about it. It just already applies to all of us. So when one parent wants to move outside of Louisiana or more than 75 miles away, you have to give proper notice. And if the other parent objects, you're going to need the court to approve it. So giving proper notice would be, I'm not going to go into it too much, but it's not filing through the court. It is literally mailing via certified mail the other party your request for relocation. You're going to want to look up this relocation statute, just quick Google, copy and paste, and you're going to go through the requirements of that. It includes the location and the proposed relocation date. And then the other parent has an ability to object, either in writing to you or by going to court and say, I object to relocation by filing a motion. And then you're going to, if they're in court, you're going to have to go and say, well, Your Honor, here's all the really good reasons that I have for wanting to move to this place. And I'm going to go ahead and give a bit more advice on that. And that is, do not go to court and say, Your Honor, we've got to move because this place sucks. Because guess what? The judge lives here and the judge's kids probably live here and the judge probably likes where they live because they've chosen to live there. So don't say that. You'd really want to say, we've got to go to this place because it's going to have an amazing school. And I've already picked out the school and I know where I'm going to live because I have already gotten an apartment or I'm going to live with family. And I've got a great support system. I've got lots of family and friends out there. I've got the job opportunity of a lifetime for myself. It's, overwhelmingly obvious that our lives would be so much better if we moved there, not just this place stinks, right? So to keep that in mind, and that the burden you're fighting against is all of these things worth diminishing the other party's parenting time or relationship with their child? So just keep that in mind, and that it does take a little bit of time. You can't just up and go whenever you want. Unless there is, again, a small caveat, and that is if domestic violence laws apply and you are sole custodian because of certain domestic violence issues. I won't get into that, but again, consult an attorney if that is your situation. Let's see. Okay, misconceptions. Both parents have equal rights to a child until there is a court order in place saying otherwise. Children don't get to decide for themselves whether to see the other parent. There is no legal preference for the mother. Custody orders are difficult to modify, especially after a hearing. So all of these have something wrong with them, right? So both parents have equal rights to a child unless there's a court order in place saying otherwise. That's true, kind of. I have a lot of people coming into my office saying, well, he took my child or she's keeping him from me. And you're both joint custodians under the default. So each of you has the right to honestly be kind of a bad parent until the court can step in and say, hey, here's what it's going to be. I'm the referee. Here's how it's going to go. Children really don't get to decide for themselves whether to see the other parent. If you are the custodial parent or the domiciliary parent or the whatever party one, you've really got to tell your child they've got to go see party two. That's what the court has ordered. I tell a lot of people it's quite difficult when the child's no longer small enough to strap into a car seat. But you're still going to have to do your best to say, you've got to go see the other parent, unless there's something that we filed in court that says the other parent is abusive or neglectful or something like that. Yeah, this is what's been ordered. You got to go. Just because it's more fun at dad's house or cleaner at mom's house or whatever it is, this is the agreement. There's no legal preference for the mother. That's correct. There's no legal preference for moms just because, unfortunately, one party does a bit more work to give birth to the child. Once the child has been born, both parents are equal legal parents. I can understand how that can feel a bit unfair, especially in the beginning of a child's life, but that's just where the line's been drawn. And, you know, I think that's where a lot of times the 2-2-3 schedule comes in, is these parties are trying to be as equal as possible because moms don't have any less, time with their child than dad should. Custody orders are difficult to modify, especially after a hearing. Kind of true, kind of not true. If you came to an agreement, it's a bit easier to change it. The standard for changing it is different, is that just that the circumstances have changed, like we discussed earlier. But if the judge decides, after hearing both of your sides for themselves, and just grants you an order, their own order, you're really going to have to prove, like, this is harmful to the child, what's been happening. The substantial harm standard. So it is a little bit difficult, but you can also agree to modify. So if you agree, that's another thing. So we talked about online resources. I don't know if Stephanie wanted to jump on and talk a little bit more about resources. There's Louisiana Law Help, Civil Legal Navigator, freelegalanswers.org. Again, Legal Services is here. There are other organizations in the area. There's Catholic Charities, there's STAR, and then of course there's the help desks and help kiosks. Stephanie?
Thank you so much, Jessica. So right now we're going to go ahead and open it up to questions. I see we've got a few that were already entered. So I'm going to go ahead and read those out loud to you, Jessica, so that everybody can hear them. And then we'll just go from there. So first we have what will happen or what can happen if there is a judgment and neither party is adhering to the judgment.
Well, neither party is adhering to the judgment. I'm not sure if neither party is adhering to the judgment who would be asking this question. But either side can file for a rule for contempt, as we discussed earlier. Hey, the other side's not picking up on time, or not dropping off when they're supposed to, or not sending them to school, whatever it is. The rule for contempt is the piece of paper that gets you in front of the judge to say, hey, the other party is not adhering to this judgment. But if you're saying that neither party is adhering to the judgment, that may come back on you, because if you are saying they're always late, but you're always late too, might kind of bite you there. But if neither party is adhering to judgment because they want to change it, they can file for a modification, which we mentioned earlier as well. And then you can change that judgment to fit whatever it is that isn't working for the two of you.
Great. Our next question is, what can be done if a parent moves and stops communicating with the other parent?
So that is a violation of the relocation statute. If they moved without your knowledge, first of all, or they moved without court approval, you're going to want to go and file for, unfortunately, a civil warrant to be issued, or at least file for custody. And I don't want to get too far into the weeds on this, but I don't know if there's been a custody order already implemented, or if this was one where the person just upped and moved and there was no custody order. You're going to want to talk to an attorney about filing for custody or modifying custody, and possibly seeking a civil warrant for the return of the child in violation of the relocation statute.
Our next question is, if you have, is there a default judgment entered if the other parent is never served with the court date?
If the other parent is never served with the court date never happens. You don't get a judgment. The other party has to be served. So part of your due process rights coming out of the 15th and 14th Amendment is that you have the opportunity to know about being sued or about big changes that are going to affect you. So if you file something in court, the other party, I don't care if the bank files it or someone else is suing you for something else totally unrelated to domestic issues, you have to have notice. And that's what the service part is. They don't have to come if they've been served. If they don't care and they don't want to do anything, then sure, the judge can just go ahead and grant judgment as prayed for, which is what I think you're asking when you say default judgment. But you have to have service. There's ways to get service. Even if the other party doesn't want to be served, they're dodging service, you can seek a private process server. You can seek a private process server that is a paid server, like a protective, not a protective, a PI. And then you can also seek a curator, which is another attorney who comes on, hopefully pro bono, but also difficult to find sometimes, and says, hey, Your Honor, I've done all these searches. I'm representing the absent party, and I've submitted sort of a note of evidence that says, here's all the things that I did to try to find this person, and they're truly absent. You may now proceed without serving this person because they're deemed absent. But you can't just not serve people and then like, oh, well, it's been long enough. I guess we'll just give you a judgment. Unfortunately, it doesn't work like that. And I have a lot of clients who are quite upset sometimes. Like, it is really hard sometimes to get people served.
And this next question, it was posted in the chat early on, so I think it's a clarification of something in your presentation. It said, so would a person need to file for both legal and physical custody?
So when you file for custody, let's say you were to file on your own, usually the forms, I wish we had some of the forms kind of up, I could kind of show you, but it'll ask you, do you want joint or sole custody? And then it'll ask you further in and it'll say, what is the best interest of the child? You know, who's going to have physical custody of the child? And sometimes even the form will say, like, in your own words, what do you want the schedule to be? And you can say, yes, every other weekend for parent two and holidays or whatever it is. So you don't need to, but if you were typing it, right, if your attorney was typing it, they would definitely want to mention those things, but they'll know to do that.
We're also getting, let's see, a few questions in the chat from Fairwood Library. I'm not going to read them to you because it seems to be very specific to
Very
the
specific.
current case and asking how to proceed. And I just want to remind viewers, unfortunately, we're not here. Jessica's not here to give legal advice. We're only giving legal information during these educational webinars. So if you have a generic question about a specific issue, or, what the law says regarding something, specific, not specific to your case, we can answer that question. But unfortunately, the questions you're asking in the chat do seem very specific to your own case, seeking legal advice. And I would highly recommend you seek advice from an attorney, and we'll go over some options maybe where you might be able to find one in just a minute. We did get another question. What happens if one or both parties did not show to the hearing after being served?
So one or both parties, that's a little bit of a confusing question. So if one party doesn't show up, it depends on who it was that doesn't show up. Is it the filing party? If the filing party doesn't show up in either of those occasions, probably going to be dismissed because they're the one moving the court to do this. If it's the party who's being served with the petition and they didn't file anything in return, you'll just go forward with your hearing with just your side, or you can ask for judgment as prayed for. Just depends on the judge how that's going to go. I have a lot of clients going, oh, if they don't show up, are we just granted what we want? Depends on the judge. The judge may make you sit there and answer all the questions and present all of your evidence just to make sure that they, have all their P's and Q's marked, all the I's dotted, T's crossed. So it just depends on who doesn't show up. And I hope that was helpful. And Stephanie, I did want to say there is one in the chat that I am going to answer because it's so vague. How should I proceed in court without an attorney? You're going to want to go ahead and get all your evidence together. You're going to want to prepare yourself about what you want to tell the judge. Again, I don't know your specific situation, but if you truly don't have access to an attorney and there's no legal aid wherever you are, or they haven't been able to accept your case for whatever reason, make sure you get all your evidence together. Make sure that you read what they served on you. A lot of times people go, I'm not really sure. Read it 15 times if you need help. Get help. Go to the library and ask for someone to help read it out with you. I think that's a really big thing. Okay, actually, it's not as scary as I thought because now that I've read it with someone is helpful. But it sounds like you do know what they filed against you. Read over it anyway. Make sure you know what time. Get your evidence together, and you'll be able to say your part because it'll be party one gets to go, and then you get to go. You get your turn even if you didn't file anything. So just want you to be aware, like you will get to speak.
Thank you for doing that. Also, when we go through some of the additional resources that we have on the State Bar Association's website, we have a self-help page. where you can get resources to represent yourself. There's some videos in there on how to present evidence, how to present yourself in court when you're representing yourself. So be sure to check those out as well. We do have another question in the Q&A. Just to clarify, one party isn't able to adhere to the judgment because the other parent who isn't because the other parent isn't adhering to the judgment.
So I think that same advice applies. You're going to need to get in front of the judge, right? Because if you can't work it out amongst yourselves, you need a referee, and that's what the judge is.
All right, and let's see, just checking to see if there are any other questions. Okay, I don't see any, but we'll still leave it open. In the meantime, I will go ahead and go over some of those additional resources. Let's see. I can share my screen. Here we go. Okay, so for additional assistance, as I mentioned, let's see. You can go to our the State Bar Association, the Louisiana State Bar Association, their Find Legal Help page, which is listed here. This is a little flyer that shows all the different options of resources, the continuum of resources that you can find through the LSBA's Find Legal Help page. A lot of these include our attorney directory, where you can look up any attorney in the state. There's the Civil Legal Navigator. There's legal aid and pro bono organizations. You can find them by parish. So you can use the drop-down menu and select whatever parish you're in, and it will give you the nearest office to your location. There's the Modest Means directory and also self-help services. And as I mentioned with those self-help services, they will, again, there's a drop-down menu where you can look for resources in your parish. There's also court forms that Jessica had mentioned. They're available there as well. And then, as I mentioned, there's these videos on how to represent yourself in court, how to introduce evidence. If you are representing yourself, I highly recommend you checking those resources out. I'd also just like to call special attention to a few of the other resources, such as the Louisiana Civil Legal Navigator. This is a great sort of diagnostic tool that helps identify your legal issue or issues, and provides customized information, referrals to legal aid, and more. It's simple. It will give you next steps specific to your issue and or your parish or location. So I would definitely start there as the first option. And then you can also use our free legal answers, which is an online pro bono program that allows users to log in whenever and wherever they like, and they can ask their civil legal questions through this portal. And they have attorneys that may answer those questions through this site. It is completely private, and it acts almost like an email exchange between the user and the attorney. But please note that users must meet certain income guidelines to use this program. And I'm going to do one more check. Let's see, we might have some more questions. Okay. There are, but it looks like it's clarifying something maybe that was said earlier about when they were going to court. And then a thank you for sharing your information and knowledge, Jessica. And so I'm not seeing any other questions. Let me check the chat one more time just to make sure there weren't any hidden in there. I don't see any. So with that being said, that concludes our Law Talks presentation for today. Please save the date for our next Law Talks, which again will be during Lawyers and Libraries Week. So that's tomorrow at noon. We'll be hosting a presentation on interdictions, guardianships, and alternatives. And there's others throughout the week, wills and estate planning, and how to navigate online legal resources. So feel free to catch any of those out. They all start at noon. You can register for more information at or register to participate in the Zoom by going to the www.louisianalawyersandlibraries.org. And that's it. Thank you again, Jessica. This is a really great presentation, and we appreciate you doing this for us. And I hope everyone has a great day and a great rest of your week.
Thanks.